Hi, J Factor, the keyboard for the Cheeseman Gillard 2C58-4 handgun carry case. Just waiting and waiting to be heard in the New Jersey Supreme Court. I'm also a contributor to the Jensen amicus brief in the Rogers case, the amicus brief that was put together for Cheeseman Gillard and CNJFO. So I want to talk about Rogers. I want to talk about the amicus brief in Rogers. But I also think it's important because this matters whether the case is Rogers, whether the case is New York Pistol, whether the case is Cheeseman Gillard. This matters. So what I want to talk about today is I want to talk about qualifiers. The qualifier, I'm gonna just read it for you the way I understand it. So, qualifier are words and phrases that are added to another word to modify its meaning, either by limiting it or by enhancing it. So I think it's very important, if you're following Rogers, Cheeseman Gillard, the New Jersey Magban case, New York Pistol. There's actually another case in upstate New York that's going on now. Gould in Massachusetts, the Young case down in Hawaii. Whatever you're following, whatever you think your case is going to be to get into the Supreme Court. I'm going to read you a paragraph from Heller. And what I want you to remember is the word modifier, okay? Because it's very important. Let me give you a little background to the paragraph. There were a lot of scholars and linguists that submitted amicus briefs for the anti-gun side during the Heller case. And their view was that the Second Amendment was a state's right and only guaranteed the right to carry a weapon in a state-organized militia. And one of the things that they did is they went back into Pennsylvania and some of the other state constitutions that were around prior to the federal constitution that had the hunting clause added to it. So it was our Second Amendment, well-regulated militia necessary to a free state, the right of the people to keep and bear arms for the defense of the state and for hunting shall not be infringed. So they kind of zoomed in on that "and for hunting" clause to say that the previous portion of the amendment meant that you could only carry arms in the state-organized militia. Anyway, Scalia knocks that down. And this is what Scalia said, and I'm going to read it so it's perfect for you because I can paraphrase it, but I think it has to come out in Scalia's words for everybody to understand where we're going with this. A propositive qualifying phrase that contradicts the word or phrase it modifies is unknown this side of the looking glass. If bear arms means, as we think, simply the carrying of arms, a modifier can limit the purpose of the carriage. Quote, for the purpose of self-defense, end quote, or, quote, to make war against the king, end quote. But if bear arms means, as the petitioners and the dissent think, the carrying of arms only for military purposes, one simply cannot add, quote, for the purposes of killing game, end quote. The right to, quote, to carry arms in the militia for the purpose of killing game, end quote, is worthy of a Mad Hatter. Thus, these propositive qualifying phrases positively establish that, quote, to bear arms, end quote, is not limited to military use. So that's Heller at 2795 and 2796. There's two things I think you should take away because I think it's super important. The first sentence is this. If bear arms means, as we think, simply the carrying of arms, a modifier can limit the purpose of the carriage. Let's take the first half of that sentence. If bear arms means, as we think, simply the carrying of arms. Move that sentence around, throw an ellipsis in there. We think bear arms means simply the carrying of arms. That's from Scalia and the 5-4, or the 5 in the 5-4 decision. We think bear arms means simply the carrying of arms. Okay? Now, let's talk about the modifier. If bear arms means simply the carrying of arms, a modifier can limit the purpose of the carriage. Okay? When Scalia is talking about modifiers here, he's really discussing that clause in the Pennsylvania Constitution for the purpose of killing game. But what he says here in 2796, a modifier can limit the purpose of the carriage. Go back to the original sentence. A purposive qualifying phrase that contradicts the word or phrase it modifies is unknown this side of the looking glass. Well, that's exactly what New Jersey does with 2C58-4. And that's actually just recently in 2018. Up until 2018, it wasn't 2C58-4. It was the Siccardi rule, which came out in 1970. It's an illegal law, never made it through the Administrative Procedures Act. It got picked up in Priest in 1990. And let me read that to you because I think it's important that we get that right as well. This is coming straight off of Priest at page 571, which is the New Jersey Supreme Court in 1990. Under the Siccardi rule, there must be an urgent necessity for self-protection. The requirement is of specific threats or previous attacks demonstrating a special danger to the applicant's life that cannot be avoided by other means. Generalized fears for personal safety are inadequate, and a need to protect property alone does not suffice. So let's go back to the Second Amendment. A well-regulated militia necessary to a free state, the right to keep and bear arms cannot be infringed unless the applicant does not have an urgent necessity as determined by a Superior Court judge in New Jersey. That doesn't make any sense. Let's go a little further. Second Amendment. Well-regulated militia necessary to a free state, the right of the people to keep and bear arms shall not be infringed unless the 2C58-4 applicant has never been threatened. Let's go a little further. Well-regulated militia necessary to a free state, the right of the people to keep and bear arms shall not be infringed unless the applicant has never been attacked previously. You see what the modifier does? So, I don't care what you call it. Let's call it the newest clause in 2C58-4, which basically put NJAC, which is NJAC is New Jersey Administrative Code, NJAC 1354-2.4D-1 is the Siccardi rule. So 2.4D-1 is the requirement is of specific threats and previous attacks demonstrating a special danger to the applicant's life. I love that term, special danger. I mean, this is how absurd it is. Second Amendment. Well-regulated militia necessary to a free state, the right of the people to keep and bear arms shall not be infringed only if the people have a special danger. That doesn't make any sense. Let's go to Siccardi, okay? Siccardi wants the permit so that he can carry a gun concealed on his person during trips to the theater, to the bank depository, and on the trips between the theater and his home. That's Siccardi from page 548 in 1971. Let's go to the Second Amendment. Well-regulated militia necessary to a free state, the right of the people to keep and bear arms shall not be infringed unless the people want to make trips to the bank to make nighttime deposits. See, that's a modifier. They have now modified the Second Amendment, except that that qualifying phrase contradicts the Second Amendment. Let me go on. Let me stop briefly here for a second. When I read that last clause in Sicardi, did you pick up the word concealed? This is one of the problems New Jersey has. New Jersey has morphed open carry and concealed carry into one form of carry. So they've outlawed concealed carry without a permit, but you can carry with a permit. They've outlawed now open carry without a permit, but you can carry open with a permit. So New Jersey doesn't really care whether you carry concealed or open as long as you have the permit. The problem is that the precedent for all their permit carry law came from anti-concealed carry, anti-crime law back in the 1800s. So they never speak of lawful carry. They're always talking about unlawful carry. So whether they're talking about concealed carry or carrying without a permit, they're never basing New Jersey law on lawful carry. Anyway, let's get back to Sicardi. So I'm on page 551. Quote, Chief Haney of the Cranford Police Department knew of no instance in Cranford where a permitted gun was used to thwart a holdup to protect the permittee. He considered that the private person's possession of a concealed weapon did not serve as a detriment to crime. Well-regulated militia necessary to a free state. The right of the people to keep and bear arms shall not be infringed unless the chief of police determines that the permitted weapon will not serve to deter crime. You see how absurd that is? And I think one of the things that it's important to remember is that the reason that hunting and killing game clauses in the Pennsylvania Constitution and the other state constitution is because back in the 1600s in Britain, in the English Bill of Rights, they had their own version of our Second Amendment. And so to get around that, what the government did was they installed these anti-hunting laws. They called them game laws. And basically it was saying that the game is ours, and because it's ours, you can't hunt it and take it for your private use. So the game laws prevented you from carrying a weapon, because if you were carrying a weapon, they said that you were carrying a weapon to steal the game, and that's how you were prosecuted. So that's how they disarmed their political opponents, was with these game laws. Let's get back to that's why those pro-hunting clauses are in some of the Second Amendment analogs prior to and just after the federal Constitution. Let's get back to Sicardi for a minute. Sergeant Klaus expressed agreement with the testimony of the police chiefs, noting that the concealed weapon does not operate as a deterrent and that attacks happen with so much suddenness that they would have very little chance to use the firearm in the event that they were called upon to do it. A well-regulated militia necessary to a free state, the right of the people to keep and bear arms shall not be infringed unless the state police think the attack is going to happen suddenly. You see how ridiculous these modifiers are? The grant of a permit to Sicardi to carry a concealed handgun on his person or in his automobile would, as all the expert testimony indicates, afford hardly any measure of self-protection and would involve him in the known and serious dangers of misuse and accidental use. Well-regulated militia necessary to a free state, the right of the people to keep and bear arms shall not be infringed unless it's dangerous. You know, I don't have to go into the whole Catano thing in the Statute of Northampton. Everybody knows guns are dangerous. They have to be dangerous and unusual. You can't just say guns are dangerous to outlaw them, because that's the whole point of the gun, is that it's dangerous. Let's read that again, though. As all the as all the expert testimony indicates, afford hardly any measure of self-protection. Well-regulated militia necessary to a free state, the right of the people to keep and bear arms shall not be infringed unless the police chief thinks it will afford hardly any measure of self-protection. You see how crazy the Sicardi rule modifiers are? You see how crazy New Jersey's modifiers are? So, what are New Jersey's modifiers, right? New Jersey's modifiers: previous attacks, specific threats, a special danger. You could take one, you could take all three. Stick them in as a modifier to the Second Amendment. They overturn the Second Amendment. Unheard of, this is not me, this is Scalia. Unheard of this side of the looking glass. Remember, we just need one win in the Supreme Court. It doesn't matter if it's New York Pistol, it doesn't matter if it's Rogers, it doesn't matter if it's Cheeseman Gillard, it doesn't matter if it's Gould, it doesn't matter if it's the case in Hawaii Young. The prosecutors and the state attorney generals are cherry-picking Heller as an inside-the-home case. If you've watched these videos, you know that's not true. No reason to stretch this out and make it any longer. What you need to know: there are no modifiers allowed on the Second Amendment, which means the state cannot prevent Cheeseman and Gillard, Rogers, from a 2C58-4 permit based on their modifiers. Previous attacks, threats, special dangers. That has been thrown out 2008 on page 2795 and 2796 of Heller. When people try to tell you about misuse and accidental use, it's fabricated, it's a modifier. New Jersey's not allowed to do it anymore. We just need one of these cases to get to the Supreme Court. Again, I'm Jay Factor. I hope this helped. Understand Rogers, Cheeseman, Gillard, and the Magban, quite frankly. I mean, let's go back to the Magban real quick. I didn't touch on it. A well-regulated militia necessary to a free state, the right of the people to keep and bear arms shall not be infringed, but the people can only carry 10-round magazines. You see the modifier? It's ridiculous. Again, Jay Factor, keyboard for Cheeseman Gillard, involved as a author in the CNJFO Cheeseman Gillard amicus brief that Jensen wrote. That's in SCOTUS right now for Rogers. I hope this helped. I'll see you next time. Thanks.